I never thought a snowstorm would lead me to a courtroom, but when Karen Whitmore demanded my Plow guy's information and then proceeded to make his life a living hell, I had no choice but to fight back with everything I had. My name is Nathan Norris, and I had been living peacefully in the Meadowbrook Estates subdivision in Burlington, Vermont, for 3 years before all this madness started. The subdivision was one of those planned communities with neat rows of colonial-style homes, manicured lawns, and an HOA that I mostly ignored until they made it impossible to do so. I worked as a software developer from home, which meant I could mostly avoid the neighborhood drama that seemed to swirl around certain residents. My house was a modest 3-bedroom with a long driveway that became a real problem every winter when the snow started falling. Vermont winters are no joke. We are talking about multiple feet of snow accumulating over the course of a season, and my driveway was particularly susceptible to drifting because of how it was positioned relative to the prevailing winds. I had tried doing the shoveling myself the first winter, but after throwing out my back twice, I decided to hire someone. That someone was Miguel Torres, a hard-working guy in his early 30s who ran a small snow removal business with his brother. Miguel was reliable, affordable, and did excellent work. He would show up within hours of a snowfall, clear everything perfectly, and never damaged my property. He was exactly the kind of contractor you wanted. The trouble started in early January during one of those classic nor'easters that dump 2 feet of snow overnight. I woke up at 6 in the morning to find my driveway completely buried, and I immediately texted Miguel. He responded within 10 minutes, saying he would be there by 8. True to his word, his truck rumbled up right on schedule, the plow blade already angled and ready. I watched from my kitchen window as he made quick work of the heavy, wet snow, pushing it into neat piles at the edges of my property where it would not block anything. I was pouring myself a second cup of coffee when I saw her marching across the street. Karen Whitmore, the self-appointed queen of Meadowbrook Estates and the vice president of our HOA board. She was in her late 40s, always dressed like she was about to attend a country club luncheon even when trudging through snow, and had that particular haircut that had become synonymous with demanding to speak to managers everywhere. I felt my stomach sink as I watched her approach Miguel's truck, gesturing wildly. I quickly pulled on my boots and coat, heading outside before things could escalate. The cold hit me immediately, that biting Vermont cold that feels like needles on your exposed skin. I could hear Karen's voice before I was even halfway down the driveway. "This is completely unacceptable. You are pushing snow onto common areas. Do you have authorization to work in this neighborhood? I need to see your permits right now." Miguel stood beside his truck, looking confused and uncomfortable. "Madam, I am just clearing Mr. Norris's driveway. The snow is on his property line just like he asked." "That is not what I see, and who are you to tell me what I am seeing?" "I am the vice president of this HOA, and I demand to know who you are and what company you work for." I stepped between them. "Karen, good morning. This is Miguel. He is my contractor. Everything is fine here." She whirled on me, her face already red despite the cold. "Nathan, this is highly irregular. All contractors working in Meadowbrook Estates need to be vetted and approved by the HOA board. You cannot just hire random people to work on your property." "That is not in our HOA bylaws," I said, keeping my voice level. "I checked when I hired Miguel 2 years ago. Homeowners are free to hire whoever they want for work on their own property." "The bylaws are being updated," she snapped. "And regardless, he is creating a hazard by pushing snow inappropriately." "I need his full name, business name, license number, insurance information, and contact details immediately. Miguel looked at me uncertainly. I shook my head slightly. Karen, Miguel is doing exactly what I hired him to do, and he is doing it correctly. You do not need his information because he has not done anything wrong. I will be the judge of that. As vice president of the HOA, I have the authority to investigate any potential violations, and that means I need to be able to contact contractors working in our community. Now, are you going to provide the information, or do I need to call the police? I felt anger flare up inside me, but I kept it controlled. You can call whoever you want, Karen. Miguel is not obligated to give you anything, and neither am I. Now, if you will excuse us, he has work to finish. Her eyes narrowed dangerously. This is not over, Nathan, not by a long shot. She turned and stalked back to her house, which was directly across the street from mine. I watched her go, feeling a sense of dread settle over me. Karen was known in the neighborhood as someone who held grudges and who used her position on the HOA board to make life difficult for anyone who crossed her. I am sorry about that, I told Miguel. You did nothing wrong. Just finish up whenever you are ready. Is she going to be a problem? Miguel asked, worry clear in his voice. Probably, I admitted. But do not worry about it. I will handle her. Famous last words. Over the next few days, I tried to put the incident out of my mind. But then, I got an official letter from the HOA, signed by Karen and the president, a retired accountant named Donald Prescott, who generally let Karen run things however she wanted. The letter informed me that I was in violation of Article 7, Section 3 of the HOA bylaws regarding contractor approval, and that I had 72 hours to provide full documentation for Miguel Torres and his business or face daily fines of $100. I read the letter 3 times, my disbelief growing with each reading. I immediately pulled out my copy of the HOA bylaws, the ones I had received when I purchased my house. Article 7, Section 3 dealt with major renovations and required advance notice to the HOA, but it said nothing about routine maintenance contractors like lawn care or snow removal services. This was complete nonsense. I scanned the letter and emailed it to a real estate attorney I knew named Patricia Chen. She got back to me within a few hours, confirming what I already suspected. The HOA had no legal authority to demand information about my snow removal contractor, and they definitely could not fine me for refusing to provide it. She advised me to send a formal response denying the violation and citing the actual bylaws. I drafted a carefully worded letter that night, explaining that Article 7, Section 3 did not apply to snow removal services, and that I would not be providing Miguel's personal information. I also reminded them that any fines assessed without proper legal basis would be challenged. I sent it certified mail the next morning. The response came faster than I expected. 2 days later, I received another letter, this time much more aggressive in tone. Karen had convinced Donald to claim that snow removal fell under property modifications, and that my refusal to cooperate was creating a hostile environment within the community. The letter demanded a hearing before the HOA board and threatened legal action if I did not comply. It was ridiculous, but I knew I had to take it seriously. HOA disputes could spiral out of control quickly, and I had heard horror stories about homeowners being buried under mounting fines and legal fees. I called Patricia Chen again and retained her formally to represent me at the hearing. The hearing was scheduled for a Monday evening at the community clubhouse, a bland building near the neighborhood entrance that hosted everything from board meetings to children's birthday parties. I arrived with Patricia, who was a sharp woman in her 50s with decades of experience in property law. Karen was already there, sitting at a long table with Donald and the other board members. She gave me a look of pure triumph when I walked in. The hearing was a farce from the start. Karen presented a rambling case that Miguel's snow removal techniques were dangerous, that he was unlicensed, he was not, and that my refusal to provide his information was obstructing the HOA's ability to maintain community standards. She had even printed out photos of my driveway after Miguel had plowed it, circling areas where she claimed snow had been pushed onto common ground. The photos were laughable because they clearly showed the snow within my property lines. Patricia dismantled Karen's arguments methodically. She cited the specific bylaw language, showed that it did not apply to routine maintenance, provided Miguel's business license and insurance documentation, which I had obtained with his permission, and pointed out that every single one of Karen's photos actually proved Miguel had done his job correctly. By the end of Patricia's presentation, even Donald looked uncomfortable. But then Karen played her trump card. Even if the current bylaws do not explicitly require contractor approval, she said, her voice dripping with false sweetness, the board has the authority to create new rules in the interest of community safety and standards. We will be voting tonight to amend the bylaws to require all contractors to register with the HOA before performing any work within Meadowbrook Estates. And Nathan's continued obstruction shows exactly why we need these rules. My jaw dropped. You cannot be serious. You are creating a new rule specifically to punish me for not giving you what you want. We are protecting the community, Karen said primly. All in favor. Donald and two other board members raised their hands. The vote was 4-1, with only a younger board member named Rachel Stevens voting against it. I felt rage boiling up inside me, but Patricia put a calming hand on my arm. This amendment is procedurally improper, Patricia said firmly. You did not provide advance notice to homeowners as required before changing bylaws. This vote is invalid. Karen's smile did not waver. We are exercising emergency powers under Article 12. The notice requirement can be waived when immediate action is necessary to protect community interests. That is an abuse of authority, Patricia shot back, and you can be sure we will be challenging this. Challenge all you want, Karen said, but until a court tells us otherwise, this is the rule. Nathan has 72 hours to comply or the fines begin. Meeting adjourned. I left the clubhouse feeling like I had just been mugged. Patricia assured me we had a strong case to challenge the amendment, but legal processes took time. In the meantime, I was stuck between surrendering to Karen's power trip or racking up fines. I went home and called Miguel, explaining the situation. I offered to provide his information to the HOA if he was comfortable with it, making it clear that I would never force him to do anything. I do not mind you giving them my business info, Miguel said. But I have a bad feeling about this, Nathan. That woman seemed really angry. I know, I said, but hopefully this will satisfy her and we can all move on. I submitted Miguel's business information to the HOA the next day. For about a week, things were quiet. We got another snowstorm. Miguel cleared my driveway without incident, and I started to think maybe Karen had gotten whatever satisfaction she needed from forcing me to comply. Then, Miguel called me on a Sunday afternoon, and I could hear the stress in his voice immediately. Nathan, I need to talk to you about something. That woman from your neighborhood, the HOA lady, she has been calling me nonstop. My heart sank. What do you mean nonstop? I mean 20, 30 calls a day. She started Tuesday. At first she was asking questions about how I do my work, what equipment I use, stuff like that. I answered politely because I thought it was part of some HOA thing. But then she started calling at weird hours, like 6 in the morning or 10 at night, and the questions got stranger. She wanted to know where I lived, where my kids go to school, whether I had ever been arrested. I stopped answering, but she just keeps calling, and she has been leaving these really nasty voicemails. I am so sorry, Miguel. Can you forward me some of those voicemails? Yeah, I will send them now. But Nathan, there is more. She showed up at another job site I was working on Friday. Just appeared out of nowhere and started filming me with her phone, saying she was documenting unsafe practices. My client was really upset and almost fired me on the spot. I managed to explain it was some crazy HOA thing, but it was humiliating. I felt sick. Did you tell her to stop contacting you? Multiple times. I told her Thursday that I did not want her calling anymore, that she had my business email if she needed something official. She just laughed and said she had every right to verify contractors working in her community. Nathan, I think she is trying to destroy my business. She left a 1-star review on my Google page claiming I damaged property and refused to take responsibility. It is a complete lie, but now people are seeing it. Forward me everything, I said immediately. Every voicemail, every call log, screenshots of the review, everything. This has gone way too far. Over the next hour, my phone blew up with messages from Miguel. The voicemails were even worse than I had imagined. Karen's voice, usually so controlled and precise, was vicious. In one, she called Miguel an incompetent hack who should not be allowed within 50 miles of snow removal equipment. In another, she threatened to report him to the state licensing board for violations he had not committed. The final one, left at 11:30 at night, was just her breathing heavily into the phone before saying, "You have no idea who you are dealing with." I sat at my kitchen table, listening to the messages over and over, feeling my anger transform into something colder and more determined. Karen had not just crossed a line. She had obliterated it. She was harassing an innocent contractor because I had dared to push back against her authority. And she was using information that she had only obtained because of the HOA's improper bylaw amendment. I called Patricia Chen first thing Monday morning. When I played her the voicemails, there was a long silence on the other end. Nathan, this is harassment. Clear, actionable harassment. And possibly stalking, given that she tracked him down at another worksite. Miguel needs to file for a restraining order immediately. He is worried about making things worse, I said. He is an immigrant. His English is great, but he is scared of getting involved with courts and legal stuff. He thinks it might cause problems for his business. I understand his concerns, but he needs protection. In the meantime, you have something else available to you. You can sue Karen personally and possibly the HOA as well for this harassment. She obtained Miguel's information through an abuse of HOA authority and then used that information to harass and defame him. That is tortious conduct. Will it work? I asked. Can we actually win something like this, based on what I am hearing? Yes, this is egregious behavior, Nathan. And the fact that it is all documented makes it even stronger. We would be looking at claims for harassment, defamation, intentional infliction of emotional distress, and possibly abuse of process. If we can prove she acted with malice, which these voicemails certainly suggest, we could even pursue punitive damages. Let me talk to Miguel, I said. If he is willing to be part of this, then let us do it. Miguel was hesitant at first, worried about the time and expense. But when I explained that I would be covering all the legal costs and that he might actually be able to recover damages for what Karen had put him through, he agreed. We met with Patricia that Wednesday, and she started drafting the complaint. The lawsuit named Karen Whitmore individually and the Meadowbrook Estates HOA as defendants. We alleged that Karen had abused her position to extract Miguel's personal information, then used that information to engage in a campaign of harassment and defamation. We claimed damages for Miguel's emotional distress, harm to his business reputation, and time lost dealing with Karen's behavior. And we asked for punitive damages against Karen personally to punish her malicious conduct and deter others from similar abuse. The complaint was filed in Vermont's Superior Court in Chittenden County on a Friday afternoon. I had the satisfaction of knowing Karen would be served with the papers probably over the weekend or early the next week. Monday morning, my phone rang at 7. It was Donald Prescott, the HOA president, and he sounded panicked. "Nathan, what the hell is this lawsuit? You are suing the HOA over a contractor dispute." "I am suing because Karen used her position to obtain personal information and then harassed Miguel relentlessly," I said calmly. "If you read the complaint, it is all laid out very clearly. This is going to cost the HOA a fortune in legal fees. You are putting everyone's dues at risk because you have a personal problem with Karen." "I have a personal problem with harassment and abuse of power," I corrected. "Karen created this situation, not me. If the HOA wants to avoid liability, I suggest you talk to your insurance company and your attorney about Karen's conduct. You cannot do this to the neighborhood. Watch me." He hung up. I actually felt good. I had been pushed around by Karen and her enablers on the board for weeks, forced to watch as she twisted the rules to get what she wanted. Now it was time for some accountability. Karen's response came through her attorney 2 weeks later. She filed a motion to dismiss, arguing that she had acted within her authority as an HOA board member, and that her communications with Miguel were protected as part of legitimate HOA business. Her attorney also claimed Miguel had no standing to sue because he was not a homeowner in Meadowbrook Estates, and that I had no standing because I had not personally been harassed. Patricia filed a comprehensive response, shredding each argument. She pointed out that Karen had called Miguel from her personal phone, not an HOA line, and had done so at all hours of the day and night, which went far beyond any legitimate business purpose. She provided the call logs showing over 140 calls in less than 2 weeks. She submitted the voicemails, which clearly showed malice rather than professional inquiry. And she argued that I had standing because the harassment of my contractor had directly harmed me and occurred as a result of information obtained through Karen's abuse of her HOA position. The motion hearing was held in late February before Judge Elizabeth Morrison, a no-nonsense jurist in her 60s who had a reputation for disliking games. I sat in the courtroom gallery with Miguel while Patricia presented our side. Karen sat with her attorney, a slick guy from Burlington named Craig Hammond who looked like he would rather be anywhere else. Judge Morrison listened to both sides, occasionally asking sharp questions. When Hammond tried to argue that Karen's conduct was protected HOA business, the judge interrupted him. "Counselor, I have read the complaint and the exhibits. Are you seriously arguing that calling someone 140 times in 2 weeks, including calls at 11 at night, constitutes legitimate HOA business?" Hammond stumbled through a response about thorough vetting procedures, but Judge Morrison was not buying it. "Motion to dismiss is denied," she said crisply. "This case will proceed to discovery. I am also granting the plaintiff's request for expedited discovery given the ongoing nature of the alleged harassment. Mr. Hammond, I strongly suggest you advise your client about the risks of continuing any contact with Mr. Torres. We walked out of the courthouse into a cold February afternoon, and I could see Miguel's relief. "She believed us," he said quietly. "The judge actually believed us." "Of course she did," Patricia said, "because you are telling the truth and you have evidence. Now comes the hard part. Discovery is going to be intense, and Karen's attorney will try to make this as difficult as possible." She was right. The discovery process was brutal. Hammond filed motion after motion trying to limit what we could access, but Judge Morrison consistently ruled in our favor. We subpoenaed Karen's phone records, which confirmed the call logs Miguel had provided and revealed even more calls he had not noticed. We deposed Karen, and watching her try to justify her behavior under oath was almost surreal. She claimed she had been concerned about community safety and needed to thoroughly vet Miguel, but she could not explain why that required calling him in the middle of the night or showing up at his other job sites. We also deposed Donald Prescott and the other board members, and it became clear that none of them had authorized or even been aware of Karen's harassment campaign. Donald admitted under oath that he had only learned about it when the lawsuit was filed. This was crucial because it undermined any claim that Karen had been acting within the scope of her HOA authority. The deposition I was most interested in, though, was Karen's. Patricia conducted it in a conference room in her office building, with Hammond sitting beside Karen looking increasingly uncomfortable. The court reporter's fingers flew across her stenography machine as Patricia methodically walked Karen through every call, every voicemail, every interaction with Miguel. "Why did you call Mr. Torres at 11:27 p.m. on January 19th? Patricia asked, her tone neutral but firm. "I do not recall that specific call," Karen said stiffly. "Let me refresh your recollection." Patricia played the voicemail, Karen's voice echoing in the conference room. "You have no idea who you are dealing with." Karen's face flushed. I was frustrated. He was not responding to my legitimate questions. What legitimate HOA business requires a phone call at almost midnight? I called when I had time. I have a busy schedule. You called Mr. Torres 147 times over 13 days. Was all of that necessary to vet a snow removal contractor? I was being thorough. Did you call any other contractors working in Meadowbrook Estates with similar frequency? Silence. Karen glanced at Hammond, who remained stone-faced. "Please answer the question," Patricia said. "No," Karen finally admitted. "But Mr. Torres was the first contractor registered under the new system. A system you created specifically to obtain his information after Nathan Norris refused to provide it voluntarily, correct? The bylaw amendment was necessary for community safety." Patricia pulled out a document. "This is the meeting minutes from the January board meeting where the amendment was voted on. Can you point to anywhere in these minutes where community safety concerns about snow removal contractors were discussed prior to Nathan Norris's situation?" Karen stared at the document. It was an ongoing concern. "That is not what I asked. Were there any discussions about snow removal contractor safety before your interaction with Mr. Torres?" "Not specifically about snow removal, no." "And when you showed up at the job site where Mr. Torres was working in Essex on January 21st, had you notified that property owner you would be there?" "No." "Did you have permission to be on that property?" "It is a public street." "But you entered the private driveway of that residence to confront Mr. Torres, did you not?" Karen's jaw tightened. "I was documenting his work practices. Without permission from the property owner, and despite Mr. Torres having told you the day before to stop contacting him." "I have a right to investigate." "You have a right to ignore someone when they ask you to stop contacting them." Hammond finally intervened. "Objection. Argumentative. I will move on." Patricia said smoothly. "Mrs. Whitmore, did you post a review of Mr. Torres's business on Google?" "Yes. And in that review, you claimed he damaged property and refused to take responsibility, correct?" "Yes." "Can you provide any evidence that Mr. Torres damaged any property in Meadowbrook Estates?" Silence again. "Mrs. Whitmore." The snow was pushed incorrectly. "That is damage to common areas. But we have established through the photographs you yourself took that the snow was within property lines. So your claim that he damaged property was false, was it not? That is a matter of interpretation." "Did you contact Google to request removal of that false review after Mr. Torres disputed it?" "No. It is my opinion and I am entitled to express it." The deposition went on for 6 hours. By the end, Karen looked exhausted and furious, and Hammond looked resigned. Patricia had gotten everything she needed. Karen had no legitimate justification for her conduct, had acted outside any reasonable scope of HOA authority, and had knowingly posted false statements about Miguel's business. As spring arrived and the snow melted, the case moved toward trial. Hammond made several settlement overtures, but they were insulting lowball offers clearly designed to make the lawsuit go away cheaply. Patricia advised rejecting them, and I agreed. This was not just about money. It was about holding Karen accountable for her abuse of power. The HOA's insurance company was a different story. They had initially agreed to defend both the HOA and Karen under the HOA's directors and officers' liability policy. But as discovery revealed the extent of Karen's personal vendetta, the insurance company filed a motion to bifurcate the claims. They argued that Karen's conduct was so far outside the scope of her HOA duties that it was not covered by the policy, and they wanted to sever their defense of the HOA from Karen's personal defense. Judge Morrison granted the motion. This left Karen personally on the hook for her own defense, and Hammond withdrew shortly after, citing a conflict of interest. Karen had to scramble to find a new attorney, eventually hiring a solo practitioner named Robert Finch, who had a mixed track record. Meanwhile, the case against the HOA itself was quietly settled. The insurance company agreed to pay Miguel $15,000 for his distress and business damages, and the HOA formally rescinded the bylaw amendment requiring contractor registration. They also removed Karen from the board and banned her from holding any HOA position for 5 years. It was not everything I wanted, but it was something. The real battle was now between Karen and us. Trial was set for early June in front of Judge Morrison. Patricia spent weeks preparing, organizing exhibits, rehearsing Miguel's testimony, and developing our argument for punitive damages. We had to prove not just that Karen had harassed Miguel, but that she had done so with malice and reckless disregard for his rights. The trial lasted 4 days. The courtroom was one of those traditional New England spaces with wood paneling and high ceilings that made everything feel more serious. Karen sat at the defense table with Robert Finch, who proved to be a competent but uninspiring advocate. He did his best to paint Karen as an overzealous volunteer who had made mistakes, but had not acted with malice. Patricia's opening statement was devastating. She laid out the timeline, from Karen's initial confrontation with Miguel through the improper bylaw amendment to the sustained harassment campaign. She played selected voicemails for the jury, letting them hear the venom in Karen's voice. And she emphasized that this was not about an HOA doing its job, but about one person abusing authority to punish someone who had wounded her pride. Miguel testified on the second day. He was nervous, his hands fidgeting as he sat in the witness box, but he was honest and sympathetic. He described the constant stress of the phone calls, his fear when Karen showed up at his worksite, and the damage to his reputation from the false Google review. He had printed out emails from potential clients who had seen the review and chosen not to hire him, costing him thousands in lost income. "How did this harassment make you feel?" Patricia asked. Miguel's voice was quiet but steady. "Scared, helpless. Like I had done something wrong, even though I knew I had not. I kept thinking, why is this woman doing this to me? What did I do to deserve it?" Finch tried to rattle Miguel on cross-examination, suggesting he was exaggerating the impact and that as a business owner he should expect some negative reviews. But Miguel did not budge. "A negative review is one thing," Miguel said. "A lie posted by someone trying to destroy my business because she was mad at my client is something else." I testified on the third day, explaining how the entire situation had started and why I had refused to give Karen Miguel's information initially. Finch tried to paint me as unnecessarily combative, but Patricia had prepped me well. I stayed calm, stuck to the facts, and emphasized that I had simply been trying to protect my contractor from what I worried would be HOA overreach. As it turned out, I had underestimated how far Karen would go. The phone records expert was particularly damaging to Karen's case. He walked the jury through the call logs, showing the sheer volume and frequency of calls, many lasting only a few seconds, suggesting Karen was not trying to have conversations but rather to harass. The pattern was clear and obsessive. Karen testified on the fourth day, and it did not go well for her. She was defensive and combative, alternating between justifying her actions as necessary HOA business and claiming she had been under stress. Finch tried to humanize her, bringing out that she was a stay-at-home mother of 3 who volunteered extensively in the community. But when Patricia cross-examined her, Karen's carefully constructed image crumbled. "Mrs. Whitmore, you have heard Mr. Torres testify about the impact your conduct had on him. Do you regret any of your actions?" Karen's lips pressed into a thin line. "I regret that he took my legitimate oversight duties as harassment. That is not what I asked. Do you regret calling him 147 times in less than 2 weeks? I was doing my job. Was calling him at 11:30 at night and breathing into the phone before saying you have no idea who you are dealing with part of your job. I was frustrated. Do you believe that Mr. Torres did anything wrong in clearing Nathan Norris's driveway?" A pause. "He should have been more careful about snow placement. But the photographs show the snow was placed correctly within property lines. Do they not?" "I disagree with that interpretation." "You disagree with the evidence?" "I disagree with your spin on the evidence." Judge Morrison intervened. "Mrs. Whitmore, please just answer the questions directly." The jury was not sympathetic. I could see it in their faces as they watched Karen deflect and justify. Patricia had done her job, presenting Karen not as an overwhelmed volunteer, but as someone who had deliberately and maliciously targeted Miguel, because her authority had been challenged. Closing arguments were on the afternoon of the fourth day. Finch did his best, arguing that while Karen's conduct had been inappropriate, it did not rise to the level of malice required for punitive damages. He urged the jury to award modest compensatory damages at most. Patricia's closing was masterful. She reminded the jury of every call, every voicemail, every moment of stress that Karen had inflicted on Miguel. She pointed out that Karen had shown no remorse, had never apologized, and had continued to justify her actions even under oath. This was exactly the kind of conduct that punitive damages were designed to address. Karen Whitmore abused a position of trust, Patricia said, her voice ringing through the courtroom. She created a rule specifically to force Nathan Norris to give her information she had no right to have. And then she used that information as a weapon against an innocent man whose only crime was doing his job well. She harassed him, she stalked him, she defamed him, and when confronted with what she had done, she doubled down. This is not a case about an honest mistake. This is about deliberate, malicious conduct that destroyed Miguel Torres's peace of mind and damaged his livelihood. And it is about making sure Karen Whitmore, and anyone else who might think about abusing power this way, understands that there are consequences. The jury deliberated for 6 hours. I sat in the hallway outside the courtroom with Miguel and Patricia, drinking terrible coffee from a vending machine and trying not to imagine worst-case scenarios. Finally, the bailiff called us back in. We stood as the jury filed in. The foreperson, a middle-aged man who worked as an engineer, handed the verdict form to the bailiff, who passed it to Judge Morrison. She read it silently, her face impassive, then handed it back to the foreperson. On the claim of harassment, how do you find? We find in favor of the plaintiff. On the claim of intentional infliction of emotional distress, how do you find? We find in favor of the plaintiff. On the claim of defamation, how do you find? We find in favor of the plaintiff. My heart was pounding. Karen sat frozen at the defense table. What damages do you award for compensatory damages? $42,000. Miguel let out a breath beside me. That was more than we had hoped for on compensatory damages alone, covering his lost income, the cost of dealing with the harassment, and his emotional distress. But Judge Morrison was not done. Have you reached a decision on punitive damages? We have, Your Honor. We award punitive damages in the amount of $125,000. I actually gasped. Patricia grabbed my arm, her grip tight. Miguel looked like he might cry. $125,000 in punitive damages was a fortune. A clear message from the jury that they found Karen's conduct unconscionable. Karen made a small noise, somewhere between a sob and a gasp. Finch put his hand on her shoulder, but she shook it off. Judge Morrison thanked the jury and dismissed them, then addressed the attorneys. I will be issuing a written judgment within the week. Mrs. Whitmore, do you understand that you are now liable for $167,000 in damages? Karen nodded mutely, her face pale. This case should serve as a reminder to HOA board members everywhere that their positions come with responsibilities, not unlimited authority. Abusing that authority, especially in a manner as egregious as what was documented here, will result in personal liability. Court is adjourned. We walked out of the courthouse into warm June sunshine. Miguel was shaking, tears streaming down his face. I cannot believe it, I never thought. I was so scared no one would believe me. You did great, Patricia said warmly. You told the truth and the jury saw Karen for what she is. This is a huge win, Miguel. What happens now? I asked. Now we collect, Patricia said. Finch will probably file an appeal, but Judge Morrison's rulings were sound. Karen is on the hook for this money. If she does not pay, we can garnish wages, put liens on property, all the usual collection methods. But my guess is she will pay, or her family will. $167,000 is not something you can just ignore. Over the following weeks, the story spread through Meadowbrook Estates like wildfire. Karen became a pariah, the cautionary tale of what happened when HOA power went to someone's head. Several neighbors approached me to apologize for not speaking up when Karen had been harassing me about Miguel initially. The new HOA board, elected in an emergency meeting after Karen's removal, was falling over themselves to be reasonable and hands-off. Miguel's business actually thrived. The publicity from the case, once we got past the initial awkwardness, brought him a flood of new clients who admired how he had stood up to harassment. He hired 2 more employees and expanded into landscaping services. He sent me a gift basket with a note that just said, "Thank you for believing me." Karen's appeal was denied in August. The appellate court found no errors in Judge Morrison's handling of the case and agreed that the punitive damages, while substantial, were justified by the egregiousness of Karen's conduct. She had 30 days to pay. The payment came on the 28th day, a cashier's check delivered by Robert Finch to Patricia's office. I was there when it arrived. Patricia split the money according to what we had agreed. Miguel received the full compensatory damages plus 2/3 of the punitive damages, covering all his losses and giving him a significant financial cushion. I received the remaining portion to cover my legal fees and expenses. Patricia had worked out a favorable fee arrangement, but the case had still cost me tens of thousands. The money made me whole, and more importantly, it represented justice. I saw Karen one more time after that, on a gray October morning when I was leaving for work. She was loading boxes into a moving truck across the street, her husband helping. She looked older somehow, diminished. Our eyes met briefly. I did not smile or gloat, just gave her a slight nod and got in my car. She moved out that week, and a nice young couple with a baby moved in a month later. They introduced themselves cheerfully, made no mention of the previous owners, and were pleasantly boring neighbors. Miguel still clears my driveway every winter, though now he brings his son sometimes, teaching him the business. We have become friends beyond the contractor-client relationship, sometimes grabbing beers after particularly brutal snowstorms to laugh about how we survived them. The case had lasting effects beyond just Miguel and me. The Meadowbrook Estates HOA completely revised their bylaws, adding specific protections against abuse of authority and creating a mechanism for homeowners to challenge board actions without fear of retaliation. Several other HOAs in the Burlington area used our case as a model for their own reforms. Patricia told me she had been contacted by homeowners across Vermont and even other states who were dealing with similar HOA overreach, all inspired by the fact that we had fought back and won. I framed the local newspaper article about the verdict and hung it in my home office, not out of spite but as a reminder. A reminder that standing up to bullies, even ones hiding behind the veneer of community authority, is worth it. A reminder that regular people can win against those who abuse power. And a reminder that sometimes, refusing to back down when you know you are right leads to justice not just for yourself, but for others who come after. The Punitive Damages Award sent a message that reverberated through HOA communities across Vermont and beyond. Board members realized that they could be held personally liable for their actions, that the title of vice president or president did not grant immunity from consequences. It was a wake-up call that has likely prevented countless other cases of harassment and abuse. As for me, I still live in Meadowbrook Estates. My driveway gets plowed every winter without incident. The HOA sends out bland newsletters about community events and pool maintenance, operating exactly as an HOA should. In the background, handling the boring but necessary work of community management without drama or overreach. And every time it snows, every time I see Miguel's truck pull up to clear the driveway, I am reminded of why I fought. Not for money, not for revenge, but because Karen Whitmore demanded something she had no right to demand, and then hurt an innocent person when she got it. Because power without accountability is dangerous no matter what form it takes, even in something as mundane as a homeowners association. And because sometimes, the only way to stop a bully is to stand up and fight back with every legal tool available. The $167,000 judgment stands as a testament to that fight. It was vindication for Miguel, who just wanted to do his job without being harassed. It was justice for me, who just wanted to hire the contractor of my choice without HOA interference. And it was a warning to every Karen Whitmore out there who thinks their position gives them the right to torment others. You are not above the law, and you will be held accountable. That is the story of how a snowstorm, an HOA vice president's power trip, and one contractor's harassment led me to a courtroom and emerged with a punitive damages award that changed not just my life, but the lives of everyone who has to deal with overzealous HOAs. It was exhausting, expensive, and stressful. But looking back, knowing that Miguel can work without fear and that Karen can no longer abuse her authority, it was absolutely worth every moment. The final footnote to the story came almost a year later. I received a letter in the mail, forwarded from Patricia's office. It was from Karen. I almost threw it away unopened, but curiosity got the better of me. Inside was a single page handwritten. "Nathan, I do not expect you to forgive me, and I am not asking you to. But I wanted you to know that I understand now what I did was wrong. The therapy I have been required to attend as part of the judgment has helped me see how my need for control and my inability to handle being challenged led me to hurt someone who did not deserve it. Miguel was a good person doing good work, and I made his life hell because your refusal to bend to my will wounded my pride. That is inexcusable. I have apologized to him directly, though I know words cannot undo the damage. This is not an attempt to make you feel sorry for me or to reduce the debt I still owe. It is simply an acknowledgement that you were right, I was wrong, and I am grateful that the legal system held me accountable because I clearly could not do it myself. I hope you and Miguel are both well." I read it twice, then filed it away. It did not change anything, did not erase what had happened, but it was something. An admission, at least, maybe even the beginning of genuine understanding. I never responded to the letter. There was nothing to say. Karen had learned her lesson the hard way, paid a steep price for her actions, and hopefully would never abuse authority again. That was the point of punitive damages, after all. Not just to punish, but to deter, to teach, to prevent future harm. And it worked. The Meadowbrook Estates HOA became a model of restrained, reasonable governance. Miguel's business flourished. I continued my quiet life, working from home and dealing with my HOA only when absolutely necessary, which was exactly how it should be. The legal precedent from our case has been cited in at least 7 other HOA disputes in Vermont and neighboring states. Patricia told me that law schools have even started using it as an example in property law courses about the limits of HOA authority and personal liability for board members. From a simple refusal to hand over a contractor's information to a legal precedent that protects homeowners and contractors alike, it has been quite a journey. So that is my story. That is how Karen Whitmore demanded my Plow guy's information, harassed him into the ground, and ended up on the wrong end of a $167,000 judgment that included $125,000 in punitive damages. It is a story about standing up for what is right, about protecting those who cannot protect themselves, and about holding accountable those who abuse the small amounts of power they are given. Every winter, when the snow falls and Miguel's truck appears in my driveway, I am reminded that the fight was worth it. Justice was served, not just in a courtroom but in the real world, where Miguel can work without fear, where I can live without harassment, and where HOA board members across the region think twice before abusing their authority. That, in the end, is worth more than any dollar amount. It is the knowledge that when pushed, when bullied, when faced with someone who thought they were untouchable, I pushed back and won. And in doing so, I made my community and maybe communities beyond mine just a little bit better, a little bit safer, a little bit more just. The snow will keep falling every winter. Miguel will keep clearing it. And the Meadowbrook Estates HOA will keep running quietly in the background, exactly as it should. That is how this story ends, with normalcy restored, justice served, and a reminder that even the smallest acts of standing up to abuse can have ripples that extend far beyond what we initially imagine.